Next case is McNeill-Marks versus MidMichigan Medical Center. This is a 15-minute mini oral argument on the application. Good morning. Yeah. You have 2 minutes of a free fire zone, and you may reserve time if you wish, but we ask that you let us know what that is and keep track of your own time.
All right. Thank you. May it please the court, Kevin Kelly on behalf of the appellant McNeill-Marks. There's really just a couple points I wanted to emphasize. First, this is a statute that protects people. It's people that work. It's people that are not legal scholars. They don't have the time to sit there and guess what report means in a statute. They're living with real anxieties. Should I report this? Should I not? Am I going to be retaliated? Do I have protection? We need a definition of report that is broad enough that employees today or tomorrow or whenever the opinion comes down knows what it means. And we can put an end to this uncertainty about what some statutory language 25 years ago this court said was clear and readily lended itself to only one interpretation. It is a remedial statute and is intended to protect those people. These added requirements to the plain and ordinary language is going to deter reports because it is a hydra of arguments that this court will have to face. If you cut off the head of report to replace it with things of authority, what is the amount of authority? Are we making a charge? Is that sufficient language for a charge? It's going to multiply the anxieties that employees face. It's going to deter reports and goes against the stated purpose of the statute. Second point I wanted to make relates to the finding of this court 25 years ago that there was only one interpretation. Why in 25 years ago we knew what these words meant. We didn't need a court to tell us what these words meant.
Counsel, I'd love to jump in. Thank you. I agree with you on the Whistleblower Protection Act and sort of the notion that it's supposed to be interpreted broadly. So I totally agree with that. Obviously, the struggle we have here is the report is to counsel or the plaintiff's attorney. So I think that's the unique grappling we have in this case, very different than most cases. So what I'm wondering is, how is it a report to call your own lawyer and then also tell your lawyer don't do anything yet? Recognizing a mistake happened here, I understand that. But how do you call your own attorney who is your agent, and how do you report to yourself?
Right, so I think we need to understand, or refer to how agency relationships are built. If somebody comes in off the street and reports to you or I or whatever attorney, this is what happened to me. Well, there's no attorney-client relationship. There's nothing. You might have confidential obligations, but I'm not an agent yet, right? You can't unilaterally create.
But at this point, counsel had already been retained and was working with her, correct?
Right, but does that change? So if I report something to somebody who has acted as my agent, right, is there a plan to do anything to address this information? No. The attorney has to sit down with the person and communicate back. What would you like me to do? Here are your options. Let me give you your advice. You need to rely on that, right? When the attorney.
But that's not how we define when and under what circumstances an attorney-client relationship is formed, right? I mean, I could see the point where you look up attorneys on Google and you're like, hey, I'm going to contact you and report this thing. That's a little bit different when you already have an established relationship with somebody specific to this PPO. right? I mean, it's not that you have a relationship only and if the attorney acts on it or we sit down and have a conversation.
Right, you have a relationship, but where's the agency? What authority does the attorney have until the client has decided what's going to happen after the report's been made, right? I can't, if somebody tells any attorney that they've dealt with for years, let's say, on multiple issues, this is something new that's coming, that is happening, or this is a development on the case. There's no agency there. The attorney can't just take that information and do whatever the attorney wants with it. You have to have a discussion. What steps are we going to take?
So it depends on what's the question or what the conversation's about, and so we now have to parse out, once the attorney relationship, client privilege attaches, or the relationship attaches, they can be agents sometimes, but not all the time?
Well, I think the easier thing is to say that when an attorney receives a report, right, that simple receipt of the report is not an agency relationship, right?
But gosh, isn't most of the time when people call a lawyer who I believe I've been sexually harassed, and they talk about maybe filing a claim at the Department of Civil Rights or whatever, I mean, isn't that the very essence of the attorney-client privilege, figuring out the strategy to move forward, and then they're acting as the agent to move the case forward?
But that's exactly the point. You have to figure out what to do. The mere receipt, the receipt of the report itself, does not create that agency.
At any time during the relationship?
Right. If I go to an attorney and say, I have, someone's accused me of misconduct, or let me see, I engaged in misconduct. And that's all I say. Even if I've referred with that attorney for years and years. He's not my agent in that point, to act for that purpose.
Okay, so I want to shift gears a little bit. What do we do about the fact that assuming I agree that this could be a report, what do we do about the fact that the report was about a violation of a PPO? The hospital didn't violate the PPO. You know, obviously the concern was, you know, Ms. McNeill-Marks was concerned because someone showed up at the hospital that she had a PPO against. So she was calling her lawyer, I assume, to report the violation of the PPO. Was that a report? Was that about the hospital?
No, but there's no requirement in the text, and the Michigan courts have repeatedly said it doesn't have to be an issue with the workplace. It doesn't have to be an issue with the employer. All it has to be is a report. That's what the plain statutory language. The issue with that, I think, and many of these issues that I think that might be struggling with, that should be handled on causation. Why would an employer care about this, right? In the normal circumstance, they wouldn't. But this is a very probably factually unique
yes.
situation where the employer did because the respondent to the PPO filed a false complaint about my client saying that she accessed her information by looking up electronic medical records, which the employer confirmed did not occur. And so in the normal circumstance, you wouldn't be dealing with that. And I think that goes right to the attorney-client privilege issue, right? How would an employer ever find out about that, right? I mean, I can report to a doctor my symptoms. It doesn't mean it's not a report just because he's my doctor, right? This is the plain and ordinary meaning of these words, not some technical special requirement. So if we can use in our everyday life the word report to somebody that I have a confidential relationship with, why can't I do that in this case? There's no reason why you couldn't, right? So if an attorney, as a mere recipient of a complaint or a report, is a public body, which the case law has said it is, then whatever they report, whatever violation, because there's no modifying or limiting language of the violation or suspected violation. It's not a violation related to the employer, related to the workplace. It's just violation. I think that's much more appropriately handled in the future, right? How is this going to come to the employer's attention? 99% of the time, it won't. You know, and if it does, and I think in my briefing, Justice Zahar had used the example of a court administrative assistant, right? That's a employee of the judiciary. Why would any employer care about that? Under the plain, literal meaning of the statute, is that a report? Yes. But you deal with it on causation, because on the vast majority of times, an employer is not going to worry about it unless there was something, right, a specialized scenario. What if it related to somebody working closely with the court system, and the employer was worried that the assistant might share that information with the judge, and then they might be in trouble? Well, in that type of situation, which again probably would be rare, it's appropriate that the Whistleblower Protection Act applies. And so here, you have a unique set of circumstances. She did what she was supposed to do. She was supposed to tell her attorney, right? How do you ever bring up something in a probate court PPO hearing when you're a represented party? Right? You can't just walk into the court. You can't file your own paperwork. You have to have your attorney ask you questions at a violation hearing. And how do you have your attorney do that unless you report it to them? Right? So it's part and parcel with what they had to do. How does she take advantage of these avenues for her protection if you can't do that? And doesn't that go exactly to the purpose that we want people to be safe in reporting things and be able to get access to the courts, right? There's multiple public policy purposes that are being served by this. And so all we are asking is apply the statute, the ordinary plain meaning, which is required under the statutes, to these words. That 25 years ago, we all knew what they meant, and we didn't have to have this. And I think that's really the second point I want to get, is that you are going to see more and more cases where we can't define statutory words that we use every day. There, it was suggested we don't know where we might need to define member. Certainly, it has been brought up in this case that might need to be happening. I have a case in the Court of Appeals where, shockingly, attorneys and judges, we're debating what is the definition of law in the Whistleblower Protection Act. Okay, and so isn't this the basis of the principle of law, that you can read and understand the law? How am I going to be able to interpret this court's opinion on this case? Do I need an opinion on the opinion that sets forth the definitions of the terms in the opinion? It's ridiculous. And that's what we're moving towards, and it is violent towards the principle of law. And so here, I think our request is to please just apply the statute as written, give this lady the protection she warranted, and it would reduce the case law, the caseload in the coming future. So I'd like to reserve my time unless there's any other questions. Thank you.
May it please the court, my name is Neil Marchand. I represent MidMichigan Medical Center Alma, which is formerly known as MidMichigan Medical Center Gratiot. Excuse me. Sorry, I have a tickle in my throat today. MidMichigan asked the court to deny the application for leave to appeal because plaintiff was not engaged in reporting, as that term is used under the WPA. And I'd like to turn to Justice Welch's question about how can a report to your own attorney, a call to your own attorney constitute a report? And the answer is it never can. The Whistleblower Protection Act makes that clear in two ways. First, under the language of the statute, and the key phrasing here is that an employee or a person acting on the employee's behalf reports a violation of law to a public body. And if we first look at the word employee and public body, we can discern the legislature's intent by using different words that these have different meanings. The employee whistleblower is not the same as the public body receiver of the report. And through that, we understand that the legislature did not intend to protect reporting to yourself. And second, when we look at the phrase employee or a person acting on behalf of the employee, the clause modifies the antecedent word employee. And therefore, a person acting on behalf of the employee means an extension of the employee, their agent, someone acting on their behalf, and therefore shares their legal identity under the principles of agency law. And through that, we can determine that any communication to an agent does not constitute reporting to that separate public body. And that's even more clear in the context of an attorney-client relationship where only the client can waive the privilege. And the client controls, bless you, Your Honor, the client controls the attorney's conduct. And in that context, a privileged communication, by virtue of being privileged, the client has not waived or authorized the attorney to talk to a third-party public body. The privileged communication can never constitute a report to the separate public body. And that's clear under the facts of this case. Tammy McNeill-Marks contacted her attorney not to talk about Fields' presence at the hospital that day. She was returning her attorney's phone calls that were left, voicemail messages that were left over the prior weekend to talk about service of the PPO because the attorney was having a difficult time serving Fields. During that conversation, plaintiff mentioned that Fields was present at the hospital that day. But she expressly told her attorney to hold off on serving the PPO and to not take any action because it's rumored that Fields was very ill and that it may become a, quote, moot point because she may die. In the context of that conversation, her attorney was not authorized to take any action. And as her agent, he could not go to a separate public body to make any report. The communication remained privileged, it was not authorized to be disclosed, and it cannot constitute a report to that separate public body. Separately, plaintiff's communication with her attorney on January 13th, 2014 also does not constitute a report because the plaintiff did not specifically intend to make a charge of a violation of law against another. And in that context, we're focusing on the word report in the statute and what that means. And we discern, the Whistleblower Protection Act does not define the word report, so we first look to the surrounding language and context within which that word is used. And when we're looking at reports, it is used as a transitive verb, meaning a verb that requires a direct object to complete its meaning. An employee is not reporting nothing to a public body. The employee is reporting a violation of law or a suspected violation of law to a public body. And when that occurs, now that we know how the word is used, we can then look to the plain and ordinary dictionary definition of report as a verb. And that is to denounce to a person in authority or to make a charge of a violation against another.
Counsel, I'd love to jump in on that point. Is it always the intent? Does the employee have to intend to make a report, or could they accidentally be reporting?
I think intent is a bad word in the English language because it has too many different meanings. I think the employee has to seek to redress the violation, and that's consistent with the case law. That's consistent with Chandler, that's consistent with Brown and with Whitman, and it's consistent.
So what if, for example, a MIOSHA inspector shows up at a plant and is walking through the plant, and an employee just mentions in passing, not even necessarily knowing something was illegal, and just mentions in passing, oh yeah, we do that all the time, or don't use the right blocks in the machines or whatever, and doesn't even realize it's a violation, and the person gets fired because they did something that resulted in a violation for the company. Is that a report?
And that inquiry turns on whether the employee is seeking to redress the violation. In the context of the statute, not knowing the rest of the conversation with the MIOSHA inspector, it sounds like the employee is saying, yeah, we're having this problem all the time. In that sense, the employee wants to redress the violation of law. Just like the employee in Whitman, when he reported to the city attorney and the mayor that the city is violating the city ordinance and failing to pay me for my unused sick time. The employee's motivation, the why the report is being made, is irrelevant. The court characterized the employee in that case as being selfish. But the fact was the employee still wanted to be paid for the unused sick time and was seeking to redress the violation of law.
So in your view, right, so you always have to be thinking something was wrong and trying to redress it. That's what you would say is critical to a report.
Correct, because that is consistent with the House legislative analysis in addition to the case law and the statutory language itself, because we're not here to protect gossiping. We're here to protect employees who want to engage in report illegal activities to law enforcement. And it's that desire to report and to seek a remedy that benefits everyone that is at the heart of the Whistleblower Protection Act.
Aren't we asking an awful lot of the word report? It has to mean that it was intentional. It has to mean, at least according to the Court of Appeals, that it was as yet unknown, you know. I mean, in order to, I mean, we're trying to fit a lot of things into report as opposed to just relaying information.
Well, even relaying information based on that definition of a statute, even relaying information, the fact that the receiver of the information is the public body implies that the plaintiff employee is seeking to redress the alleged violation of law. You're not going to call the public body about something that's irrelevant. You're calling the authorities to report the violation of law.
But what about in that circumstance that Justice Welch talked about, if the employee didn't think it was in fact violative? Then I guess it's not a report because it's not a suspected violation of law?
So if in the instance where the employee has no knowledge and is just making a comment, the employee is not seeking to redress any violation of law. The employee is not denouncing any problem to a person in authority. The employee is not making a charge. The employee is simply conveying information, and it's equivalent to the Wiltsey case where the head of the police department at the Delta Community College was talking over drinks at a bar at lunchtime with his friend who was the head of another police department about a sexual relationship between the professor and a student. They're not engaging in any sort of conduct to redress the violation of law. They're just gossiping. And so an offhand comment that's not seeking to redress a violation of law is not entitled to the protections of the Whistleblower Protection Act. So we know that the legislature was not intended to, the Whistleblower Protection Act is not intended to protect gossiping. It is intended to protect employees who assist in law enforcement. And to go to your, and that's the language from the House legislative analysis that this court favorably cited in Dolan. But to go to your point about some sort of intent requirement, absent any intent requirement, this court would effectively be extending whistleblower protection to the target of an undercover investigation who makes an offhand comment to an undercover officer, and the employer learns about it and fires the person because they're doing something illegal. At that point, we have whistleblower protection for the very target of the investigation and the person engaged in the illegal activity.
What about the problem that's an issue of causation, right? Wouldn't the employer in that circumstance be able to say, I didn't fire him because he made a report that's subject to the Whistleblowers Protection Act. I fired him because he committed a crime.
And there we have an issue of fact because—
Sure,
yeah.
but I mean, but a lot of this, I think your opposing counsel is saying, look, like it may, you know, I mean, if we are putting all of this on the word report, like really where the argument should be is in the causation analysis. And maybe a plaintiff could never prove the requisite causation that the adverse employment action happened because of the report. But don't try and, you know, make the word report do all these things. Like, you know, it has to be intent. It has to be something previously unknown. It has to be, you know, all of these things. Doesn't causation, I mean, isn't that the proper focus, I think, is plaintiff's argument? Like, that's where this gets worked out.
Causation is still part of, I think it bleeds through into both portions of the analysis. If the individual is not seeking to redress a violation of law, they're also not going to establish causation for being fired for that. But the same facts in any type of scenario can impact multiple portions of the analysis, and it also impacts the conveying the information. in this portion, because going back to the legislative intent, based on the language of the statute, by having to report to that public body, it implies that the individual has to be seeking the public body's assistance in addressing the alleged violation of law. In this case, plaintiff was never doing that. She told her attorney to hold off. She told her attorney not to act. And so plaintiff did not, under any terms of report, convey any information to anyone other than her own agent, who was ethically bound not to disclose the information, and she never authorized that privileged communication to be shared with another. To address the third question the court asked us to address was whether the Whistleblower Protection Act requires the communication to be to an individual with the authority to address the alleged violation. That too is, yes, it does. And it wasn't present in this case because plaintiff expressly disavowed any authority and told her attorney not to act. But when you look at the same violation, the same language in the Whistleblower Protection Act, it is to a public body as the receiver of the charge against another individual. And that's also consistent with the House legislative analysis language from 1980 when the act was passed, as well as the 1982 when it was amended. In short, MidMichigan asked this court to deny plaintiff's application for leave to appeal for the reasons we discussed today, including the fact that a privileged communication can never constitute a report to a public body. Thank you.
Thank you.
Thank you, Your Honors. I think here the example that Brother Counsel used is important, right? So if you're thinking about the employee, a person acting on behalf of the employee, and a public body, right? When the employee reports to the attorney public body a violation of law, nothing needs to happen after that, right? There's no requirement that the public body does anything. If the attorney does choose to do something, the attorney then moves into acting on behalf of the employee, right? Which is exactly the agency relationship. Once there's been a report, there has been discussion on what we're going to do, they decide to take steps, that the employee then becomes somebody, whether that would be further protected activity, again, might be a different question. But the mere report to the attorney is a report. And I think, Your Honor, the idea that we are putting way too much into report is true. Let's look at, how do we prove the point that you have to specifically intend this? Do we infer it from the fact of the report? Well, if that's the case, every report is going to be intended, right? The mere fact that you reported it. So if it's going to be that simple, we don't need that definition. It doesn't add anything. All it is going to do is give lower courts opportunity to let biases come into this analysis, which we don't need, is not productive, is not protective of the employees. Here, and I think this is where the Court of Appeals ultimately hung their final conclusion on, is she didn't say hold off on everything. Tammy McNeill-Marks told her attorney, hold off on serving the PPO. They didn't hold off on filing the motion for contempt. It was filed days afterwards. They were intending on having the hearing in February. She was going to testify. She testified in this case that she was going to testify to all of this, but the respondent to the PPO showed up and admitted everything, and she was held in contempt. She wasn't holding off on this case. She was holding off on serving something that was going to extend the PPO. This is stuff that was the motion for contempt was initially filed over conduct that happened in the fall. So whether she calls or the conversation starts a certain way doesn't matter. Did she factually make a report that somebody violated a law? Yes. She told her attorney that she showed up at her workplace, that she communicated with her, both things prohibited by the PPO, and why did she report it? So they could bring it up and take action against it. Even if you take some convoluted definition that's going to push all these things into one word, really things that are modifying other statutory terms into this one word, she complied with that. She met that standard. She wanted something done to the person who had threatened her and threatened her life and the life of her kids multiple times. She made a report. Thank you.
Thank you both. The case will be submitted.